Hi! Hello! Welcome to our channel or welcome back to our channel if kayo ay mga nagbabalik-balik na. Okay, thank you for coming back again and again. Anyway, today we will be discussing the third mode of extinguishment of obligation. So that is condonation or remission. It's Article 1270 to Article 1274. So medyo maliit lang at madali lang to. Article 1270. Condonation or remission is essentially gratuitous and requires the acceptance by the obligor. It may be made expressly or impliedly. One and the other kind shall be subject to the rules which govern in officious donations. Express condonation shall furthermore comply with the forms of donations. So, yon. First and foremost, bago natin i-discuss yung Article 1270, i-define muna natin what is condonation. Since after all, yun na nga, we will be discussing for this video, condonation or remission. Pareho lang yun, okay? So, accordingly, condonation is defined as the gratuitous abandonment by the creditor of his right. Okay? It is actually a form of donation. Ganito lang siya kasimple, as in, promise, eto lang. Example ha, Pogi owes Ganda 1 million pesos, payable on December 25, 2020. Tapos comes December 25, 2020, sinabi ni Ganda kay Pogi na he need not pay the 1 million pesos since she was condoning it. Okay? Here, the obligation was extinguished through condonation or remission. Yun. Ganun siya kasimple. Kinondone. It is the abandonment of the creditor's right in favor kay debtor. Now, what are the requisites or ano nga ba yung mga essential requisites in order to constitute donation? Okay? I mean condonation or remission. So, the requisites are the following. First, it must be gratuitous. So, yung cause or consideration sa pag-remit or pag-condone ng credit or ng right ni creditor is no other than the liberality of the creditor. Dapat walang walang exchange. Kasi nga liberality, gratuitous, meaning freely or parang free of charge. Ganun siya. Yung kabaliktaran naman ng gratuitous, meaning may bayad, okay? So, condonation must be gratuitous. It must be free of charge. Yun siya. Now, second requisites, it must be accepted by the obligor. Yun nga, kasi di ba govern din siya, parang donation. So, kung donation, kailangan accepted ng obligor or ng, doni. Kung donation, si donor ang magbibigay, i-accept yan ni doni. So, dito naman, si creditor, parang si creditor yung nagbibigay at kailangan i-accept ni doni or in this case, si obligor kasi yung credit ang niremit sa kanya. So, actually, this is expressly required. Diba? Ni Article 1270, nilagay niya talaga doon na acceptance by the debtor. So, meaning this is a bilateral act. Third requisites, ito yung the parties must have capacity. Of course naman, capacity is always necessary in order to bind. Diba? Para may binding effect naman yung mga transactions or mga ginagawa mo. And fourth requisites, it must not be in officious. So, di ba na-discuss na natin to? Si in officious or excessive. Sabi nga, di ba, no one can give more than which he can give by will. Ito yung rationale dito, in officious. So, yung ibibigay mo, hindi naman yung sobra-sobra to the point na sinama mo na pati yung legitim. Legitim is yung right ng mga compulsory heirs mo. Yung mga mamanahin dapat yun. So, hindi mo pwedeng ibigay lahat at saka magbigay ng sobra-sobra sa kakayahan mo. Kasi that is inofficious or excessive. Otherwise, if it is inofficious, pwede siyang i-reduce ng court such that yung legitim ng mga compulsory heirs mo dapat hindi mapiktuhan. Aside sa dapat din naman yung mag-iwan ka ng para sa sarili mo, 'di ba? To support yourself. Okay, then fifth requisites is, if made expressly, it must comply with the forms of donations. Nasa kay 1270 din naman to na-mention, di ba? So, nag-require siya ng formalities, same with donation. Meaning, if it involves an obligation to give a land, di ba pag land, kailangan nasa public instrument. So, pag ganun, nag-require din ng forms na it must be in public instrument. So, if yung remission ay ginawa sa last will and testament ng isang tao, dapat yung last will din na yon is valid para maging valid din yung condonation or remission. Okay, that's it. Eto na tayo, kinds of remission. First, it is categorized as to its extent, as to its form, and then as to its date of effectivity. Pag sinabi mong extent, ano ba yung kinondone? Is it complete? Does it covers the entire obligation? Yon. Pero pag partial, when it does not cover the entire obligation, kumbaga part lang, partial, di ba? Yun lang yung binigay mo or kinondone or niremit. Tapos, yung as to its form, is it expressly, express or implied? So, if it is express, it is made either verbally or in writing. Pag implied, then ito yung mga makikita mo lang sa mga conduct, di ba? Mga implied conduct lang ni creditor. Tapos, dito naman as to the date of its effectivity, pwede siyang inter vivos or pwede siyang mortis causa. Inter vivos is when it will take effect during the lifetime of the donor. Usually, ito talaga yung donation na mag-take effect na siya kaagad habang buhay pa si donor. Pag sinabi mong mortis causa, ito naman yung mag-take effect upon the death. Binigay mo, pero mag-take effect lang siya pag namatay na si donor. Okay? So, usually, ito ay makikita sa last will and testament. Right? Anyway, mas maganda ata mag-proceed na tayo kay 1271. Madali lang naman yung 1270. Okay? Article 1271. The delivery of a private document evidencing a credit made voluntarily by the creditor to the debtor implies the renunciation of the action which the former had against the latter. If in order to nullify this waiver, it should be claimed to be inofficious, the debtor and his heirs may uphold it by proving that the delivery of the document was made in virtue of payment of the debt. Okay? So, it is another presumption. Ang sabi, ito nga actually is a presumption na in case yung document of indebtedness is voluntarily delivered by the creditor. Yun ha, ito yung presumption na to. Actually, yung question is, what is the effect of the delivery of a private document evidencing the credit? Ano ba ang epekto ng pag-deliver ni creditor kay debtor ng document which is the evidence ng utang nito? Ang sabi ni Article 1271, ang pag-deliver daw ni creditor kay debtor ng private document which is the evidence ng credit creates, ito yung sinasabi kong presumption, presumption of implied remission. Note ha, it should be made voluntarily. Okay? Voluntary niyang ginawa ang pag-deliver ng private document na which is the evidence of the credit. Okay? However, dahil nga presumption nga lang din naman, ano nga ba yung sabi ko before? Pwede pa rin siyang ma-overcome. Pwedeng mag-show ng proof si creditor na hindi niya ni-remit or walang condonation ng credit. Note ha, ito importante. This article speaks about private document, okay? So, example, Pogi issues a promissory note in favor of Ganda in an amount of 1 million pesos. Tapos later on, itong si Ganda, dineliver ang promissory note pabalik kay Pogi without collecting the 1 million pesos, ha? So, si Pogi na ulit ngayon ang in possession sa promissory note kasi voluntarily dineliver ni Ganda yung promissory note tapos hindi naman siya nangolekta ng bayad. In this case, there is a presumption na Ganda has condoned or remit the debt. Mayroong implied remission. Pero again, note, presumption lang. Pwede pa rin namang i-prove ni Ganda na walang remission or condonation na naganap, okay? Pwede niyang i-prove na iba ang purpose or intention niya kung bakit niya dineliver. Yung promissory note kay Pogi, halimbawa, baka gusto niya lang ipakita or for something, baka may iba silang usapan. But Ganda has to prove the same, okay? Kailangan niya ngayong i-prove yun. Kasi yung presumption, ni-remit or kinondone niya na yung utang ni Pogi. Yun siya. So, Article 1272. Whenever the private document in which the debt appears is found in the possession of the debtor, it shall be presumed that the creditor delivered it voluntarily unless the contrary is proved. So, Article 1272 is, karugtong lang siya ni Article 1271. As in, kasi imagine, kung si Article 1271 is about the presumption na mayroong remission or implied remission pag voluntarily dineliver ni creditor yung private document evidencing payment, di ba? Yun. Now, si Article 1272 naman tells us about presumption of voluntary delivery. Sabi niya, pag daw yung private document in which a debt appears is found in the possession of the debtor. So, pag yung private document na nandun nga yung utang, yung ebidensya ng utang, ay napunta or nakita mo na ulit nandun na kay debtor, merong presumption na voluntarily dineliver sa kanya. Okay? Voluntarily dineliver ni creditor pabalik kay debtor. So, again, unless nga the contrary is proved. Obviously, dahil nga presumption lang din naman, the creditor can always overcome such presumption. Pwede niyang i-prove na hindi na yun binigay voluntarily kay debtor. Okay? That's it. It's as simple as that. So, Article 1273. The renunciation of the principal debt shall extinguish the accessory obligations, but the waiver of the latter shall leave the former in force. Okay, so eto, ano nga ba ang epekto ng renunciation ng principal debt at ng accessory obligations? Pag ang renounce daw is si principal obligation, extinguish rin ba si accessory obligation? Well, yan ay consistent sa rule na accessory follows the principal. So, pag nagkaroon ng renunciation, remission, condonation sa principal obligation, since accessory follows the principal, di meaning, wala na rin, or ni-renounce mo rin si accessory obligation. Now, pagbaliktad, itong si accessory obligation, yun ang ni-renounce. Siya ang kinondone, siya ang ni-remit. Ang sabi, it shall leave the former in force. So, meaning, yung principal obligation is andun pa rin. It will still exist even without the accessory obligations. Now, example, si Pogi may utang kay Ganda na 1 million pesos, tapos si Beauty ang guarantor. So, sa situation na to, yung principal debt is yung utang ni Pogi kay Ganda na 1 million pesos. Yung accessory obligations is yung obligation ni Beauty as a guarantor, na pag hindi nagbayad si Pogi, siya ay magiging liable. Dahil as a guarantor alam niyo naman siguro yan, very common terms. So, dahil siya ang guarantor ni Pogi, that is actually an accessory obligation. So, in this case, if nag-remit or nag-renounce si Ganda sa utang ni Pogi na 1 million pesos, mawawala rin yung obligation ni Beauty as a guarantor. Okay? Pero, if yung guarantee lang ni Beauty ang ni-remit or ni-renounce ni Ganda, yung obligation lang ni Beauty ang mai-extinguish. Yung obligation ni Pogi will remain enforced. So, may utang pa rin si Pogi na 1 million pesos kasi yun yung sabi ni Article 1273. Remain enforced daw si principal obligation. So, that's it. Punta tayo kay last article. Article 1274. It is presumed that the accessory obligation of pledge has been remitted when the thing pledged after its delivery to the creditor is found in the possession of the debtor or of a third person who owns the thing. So, another presumption. Ito na naman. Sa contract of pledge to. Ano ba sa Tagalog yung pledge? Parang ano siya, sangla. Yes. Like yung sinangla mo yung alahas mo para makakuha ng pera, di ba? As a security na babayaran mo. So, yung alahas ay kumbaga yung guarantee na magbabayad ka, right? Anyway, sabi ni Article 1274, it is presumed that the accessory obligation of pledge has been remitted when the thing pledged after its delivery to the creditor is found in the possession of the debtor or of a third person who owns the thing. So, pag daw yung bagay na sinangla ni debtor kay creditor, so meaning dineliver mo na yung alahas mo or what kay creditor as a security dun sa loan. Later on, babalik na yon or mapapasa kamay na ulit ni debtor or kung sino man daw ang may-ari ng bagay na yon. Sabi, there is a presumption na yung pledge has been remitted. So, example, si Pogi nangutang kay Ganda ng 1 million pesos and so as a guarantee or as a security sa kanyang pagbabayad, dineliver niya ang kanyang watch worth 1 million pesos rin. So, Pogi actually pledged his watch to Ganda. Now, if later on, nakita na natin na nasa kay Pogi na ang kanyang mamahaling watch, meaning there is a presumption na ni-remit ni Ganda yung accessory obligation na pledge, okay? Please note that under Article 1274, only the accessory obligation of pledge ang presumed remitted. Hindi kasama ang principal obligation, okay? So, dahil hindi kasama si principal obligation na 1 million pesos, kailangan pa rin namang bayaran ni Pogi yun. Only that, this time, wala nang security. Wala nang pledge, so magiging pure loan na lang talaga siya. Yay! That's it! Thank you for watching. Again, if you find this video helpful, paki-like naman, share nyo rin sa iba para at least matuto rin sila dito.